What's up? We back at it again with our Constitution reading. It's the Constitution Annotated, Analysis and Interpretation of the U.S. Constitution. We're continuing our reading of the introductory material. We have our introduction and introductory annotations going on here. And where we left off, we were over here reading the Supreme Court decisions, treatment of Supreme Court's cases generally. We also read some of the methodology and the information included here. And now we're getting into some actual essay here. So we're going all the way through this section, and we are starting here with preemption cases. This is 4.3.2 preemption cases. Hopefully you can see it. We have cases determining whether federal law displaces state law are, at bottom, constitutional law cases insofar as they at least implicitly involve the supremacy clause and its mandate that the laws of the United States made in pursuance of the Constitution shall be the supreme law of the land. However, preemption cases, by their nature, tend to focus on the meaning of particular federal and state laws and are typically resolved by focusing on a specific federal statute and the intent of the Congress that enacted the statute. Many Supreme Court preemption cases do not discuss generally applicable principles for the preemption or the broader meaning of the supremacy clause, while including preemption cases that broadly shed light on the doctrine of preemption. The Constitution Annotated generally does not include cases involving the application of preemption. With respect to specific statutory schemes, statutory. Now we have some qualified immunity cases. In cases where plaintiffs seek monetary damages from the federal or state government officials and the Supreme Court, in a doctrine commonly referred to as qualified immunity, has held that liability exists only when the government official's conduct violates clearly established statutory or constitutional rights. Determining whether a constitutional right is clearly established is related to determining what that constitutional right entails. However, these two inquiries are conceptually distinct. The court has held that a court does not necessarily need to determine whether a constitutional right has been violated in order to afford a government official qualified immunity. Moreover, for a constitutional right to be clearly established, the contours of that right must be sufficiently clear that a reasonable official would understand what he is doing violates that right. As a consequence, a ruling that a government official is entitled to qualified immunity may provide little insight into the scope of the underlying constitutional right. Only qualified immunity cases that inform the general understanding of the scope of particular constitutional rights are, as a rule, included in the Constitution Annotated. Alright, so this is just priming us to know what's coming up. Alright, federal habeas claims and state court convictions. Pursuant to the relevant provisions of the federal habeas statute, a federal court may not use a writ of habeas corpus, that is, an order releasing a person from imprisonment or detention, with respect to any claim that is adjudicated by a state court unless the underlying state court decision was contrary to or involved an unreasonable application of clearly established federal law, as determined by the Supreme Court of the United States. A federal habeas petition will generally be granted as a result of a constitutional error only if the state court arrived at a conclusion opposite to that reached by the Supreme Court on a question of law, or decided a case differently than the court has on a set of materially indistinguishable facts. Or 2, identified the correct governing principle from the court's decision, but unreasonably applies that principle to the facts of the prisoner's case. As a consequence of the governing standard in habeas corpus, the Supreme Court may not opine on the scope of the underlying constitutional right, but instead merely addresses whether the state court erred in its assessment of the constitutional right, and such cases are, as a rule, generally not included in the Constitution annotated. So don't be looking for them. Don't be fucking looking for them. And now we're looking at our statutory claims. What you know about your statutory claims? When it's a government coming at you with statutory aims. I don't fucking know, man. I'm not a rapper. While the court's decision opining on how to construe a statute are generally excluded from the Constitution annotated, certain cases involving statutory interpretation may be included insofar as constitutional considerations influence the court's approach to construing legislative text, and such cases involve the doctrine of constitutional avoidance, i.e. the long-standing interpretive rule followed by the Supreme Court that counsels that when a particular reading of the statute would raise serious doubts about the statute's constitutionality, a court interpreting the statute must first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. Other cases involve the construction of statutes intended to parallel or supplement specific constitutional rights. However, as a rule, such cases are included only when the interpretation of the statute is inextricably intertwined with the interpretation of the constitutional provision. Two examples may serve to illustrate this. We got some examples. Are you ready? Talk about religious restoration, freedom, because that is holy water, motherfucker. Holy water, motherfucker. Oh. Oh my God, I'm dying. That really messed up my throat. Alright. The first involves the Religious Freedom Restoration Act of 1993, or RFRA, which Congress enacted in the wake of the court's 1990 decision in Employment Division v. Smith, repudiating the methodology used in earlier cases to analyze claims asserting a violation of the Free Exercise Clause of the First Amendment. These earlier cases had adopted a balancing test, often referred to as the strict scrutiny test, that weighed whether this challenged action imposed a substantial burden on the practice of religion, and if so, whether the challenged action served a compelling government interest. However, the Smith Court rejected that approach, allowing generally applicable laws to apply to religious practices without being subject to strict scrutiny. In response, Congress enacted a RFRA, which prohibits the federal government, as a matter of federal statutory law, from substantially burdening a person's exercise of religion unless the government demonstrates that the challenged action serves a compelling government interest and is the least restrictive means of furthering that interest. As a result, while the court's modern RFRA in jurisprudence touches on issues of religious liberty, the test imposed by RFRA is distinct from even the pre-Smith free exercise case law, and at bottom does not interpret the Constitution. As a consequence, while the Constitution annotated references certain RFRA cases, it does not purport to address RFRA cases in detail. The second example involves the Electronic Communications Privacy Act of 1986, Wiretap Act. This act authorizes a judge, after receiving an application from the government, to enter an order allowing for the interception of a wire, oral or electronic communications upon finding probable cause that an individual is committing, has committed, or is about to commit specified offenses. The Act does not define what is meant by probable cause. However, courts construing the probable cause requirement in the Wiretap Act have concluded that it is coextensive with the constitutional requirements embodied in the Fourth Amendment. Thus, the court were to rule that the Wiretap Act's probable cause requirement was satisfied in a particular case. In a particular case, this ruling would warrant inclusion of the Constitution annotated if it rests on the grounds that inform our understanding of the Fourth Amendment's probable cause requirement. Now we got some common law doctrines. Listen up here, some common law doctrines. In some cases, the Supreme Court's rulings expound upon long-established judge-made doctrines, widely referred to as the common law. Some of these common law doctrines have their origins in constitutional norms, such as the rules regarding the prudential standing, and the various doctrines requiring the suspension of the federal court proceedings in favor of a state court proceeding. Others have little to do with the Constitution and are justified by more mundane concerns, such as the need for judicial efficiency or lack of a statute or rule to resolve an existing legal issue. Cases addressed in common law doctrines with constitutional underpinnings are included in the Constitution, annotated insofar as they help to elucidate the scope of the relevant constitutional provision. You heard, your word represent. You heard, your word represent, motherfucker. Motherfucker. That concludes the Supreme Court decisions. That concludes the Supreme Court decisions. Supreme Court decision. Supreme Court decision. Supreme